Bonjour tout le monde. Hello, everyone. For those who don't know me, my name is Florian Martin Barreto. I am an associate professor of law, the University Research Chair in Technology and Society, and the director of the Center for Law, Technology and Society at the University of Ottawa. And I'm also the director of the AI and Society Initiative, that is a multi-center and multi-faculty initiative at the University of Ottawa, and that is presenting today's event. For today's virtual talk, I am delighted, and I don't use that word lightly, to be joined by Professor Kristen Thomason and Dr. Connie Chagall-Pfefferkorn to discuss how Canadian and U.S. tort doctrine can or cannot provide justice and compensation when people are injured or harmed as the result of the introduction of the use of algorithms in society. I know it's a very topical conversation and issue, and I'm so delighted to have so many people in the room today from literally like around the world. Thank you for this. And so our panelists today are so Professor Kristen Thomason, who is an assistant professor at the Peter A. Arlott School of Law at the University of British Columbia, and an associate member of the University of Ottawa Center for Law, Technology and Society. She is also completing a PhD with us. She is about to submit a PhD dissertation on discussing some of those very specific issues. It's a question of days, and I'm sure soon a book to be released about this. So keep posted about this. And our other panelist is also linked to the University of Ottawa. It's Dr. Connie Chagall-Pfefferkorn, who is currently our Scotiabank postdoctoral fellow on AI and regulation at the AI and Society initiative at the University of Ottawa. So that's why I said to earlier that I was very delighted to have two of our collaborators and colleagues and friends joining us today for such an important conversation. And to discuss this, rather than the usual panels with formal presentations as academics are used to do, we decided to have a more conversational approach. And I will have the pleasure and privilege to act as your facilitator for today's conversation. So I have proposed some questions for our panelists to also unpack some of the keywords in the title. But yeah, feel free to ask you questions in the chat. So it's the bubble button at the top or the middle of your screen. And for those who are not used to CLTS or in society event, you will see we have sometimes very lively conversation even between attendees in the chat. So ask your question, and myself or the panelists will pick on your comments and questions and fit them within the conversation. So thank you again, Connie and Kristen for joining us. And without further ado, I will start with a first question that's more like, it's maybe academics being academics, but I know there is not just lawyers in the room and not just like North American lawyers. So I thought it would be good to start by unpacking some of the keywords even in the title of the event and what we're talking about. So now I would like to hear you to start off on how would AI-based armed be treated under tort law, both in Canada and south of the border in the US. But first, maybe Kristen, if you could explain in a few words, what is tort law? What are we talking about when we discuss like, oh, it's a tort, it's not a tort? And maybe also like, what are like AI-based arm? Yeah, what could it be? So maybe Kristen and then Connie, if you want to follow up.
Great, thank you. And thank you so much for organizing and for hosting us. This is a great event. I'm really excited to be here and join this conversation. I'm joining from the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh people. But I used to live in Ottawa for a long time. And in explaining what tort law is, I may make some reference to actually some of the tort law that's been taking place in Ottawa this week, because it might be helpful, especially to those who are living the experience of what's going on in Ottawa right now. Excuse me. Also, just a preface, I'm still recovering from COVID, so please pardon me if I lose my voice or just start coughing in the middle of an explanation or something. It may happen. Just like sort of the high level explanation of what is tort law. Tort law is an area of the law which we refer to as private law, which means it refers to an area of law where people or companies can litigate for their own personal interests. So that's in contrast to, say, public law, where maybe the government would act on behalf of a concept of the collective or the public, like in, say, a criminal proceeding or a constitutional proceeding. In tort law, we're acting on our individual behalf. So trying to litigate and seek compensation for individual harms that we've experienced that can sometimes happen in the context of a group. Like you can have what's called a collective action, where a group of people who have each individually been harmed come together because they've experienced a similar harm from the same defendant. So whether that's a company or a person or a government. And I'm just seeing in the chat that the closed captioning doesn't seem to be working. I don't know if anyone's able to sort of make that adjustment as I keep speaking. So, when I said making reference to maybe an example to help clarify this, for instance, there's been a very high profile, very significant nuisance claim in Ottawa, seeking compensation, but also seeking some kind of court action to address very, very loud honking noise in the downtown Ottawa core. But to be very clear, when we're talking about tort law, as opposed to, say, public law, like a government action, what's happening there is litigation that is vindicating individuals' interests in their own property and their ability to enjoy quiet and solitude in their property. And the collective nature of it is just that there are a lot of people who live in downtown Ottawa who have an individual interest in their property. And so seen together, they can all of these individuals can get some kind of outcome, potentially compensation. We'll see how the proceedings carry forward based on that private individual personal right. So when we talk about tort law, I think it's important to sort of contextualize that there are limits to what we're talking about. We're talking about something very particular, which is some kind of legally recognized harm is being vindicated and potentially compensated through the courts. And so when I, tee it up that way, tort law is looking at specific kinds of harm. So not necessarily all kinds of harm. And that can be something that becomes complicated when we talk about algorithmic harm. And maybe I'll just give a couple of examples of algorithmic harm, and then I'll let Carney jump in as well, if you have other examples that you want to add. But there are a range of very different ideas of algorithmic harm, some of which might be recognized by tort and some of which are not, at least yet, recognized by tort. So we could range from, very intentional conduct, like the creation of deep fakes, which is the use of AI to sort of transpose someone's image into a video in which they were never actually appearing. And, this becomes very legally problematic when it's done without consent. And that could engage a number of different harms, like defamation, like a lowering of your personal reputation, or privacy if somebody's portrayed in a way that they would never have consented to. They don't want to be portrayed in that way. So there could be sort of intentional tort claims that would be triggered by something like that. Or we can have algorithmic harms that arise not because somebody meant for them to arise, but because they unexpectedly arose as a result of the way that algorithms actually work. So the way that algorithms can sometimes have what's sometimes referred to as emergent behavior or unexpected behavior. So something in that vein could be an example might be like an algorithm that's used by a bank to help make decisions on whether or not to grant someone a mortgage for purchasing a new house, and how much money should be granted within that mortgage. If that algorithm is trained on, let's say, historically discriminatory data that discriminated on the basis of location or race in determining whether somebody got a mortgage or not, it might replicate that discrimination and carry it forward into the future. And that discrimination is a form of harm. Unfortunately, that's a form of harm that has not yet been recognized in tort. The courts have actually rejected the opportunity to recognize discrimination as a form of tort harm so far. Other examples, like maybe a more obvious example, would be if the computer system that is supporting the operation of an autonomous vehicle, sends an instruction to the vehicle to do something somewhat erratic, and it causes a collision, which results in property damage, like damage to the car or someone else's property, or physical injury, like somebody gets hurt in a collision. That would be a very obvious instance where tort law might be engaged, because tort law often vindicates property and personal damage. And then two slightly more abstract examples, and then I'll turn it over to Carney. The failure to use artificial intelligence can also be potentially seen as an algorithmic harm. So an example of this could be like in a medical setting where it becomes standard practice to refer to, say, a computer system-based diagnostic program. The failure of a doctor to refer to that program could eventually become something that could be litigated as a tort harm. There's some fantastic work written thinking about that. I'll post some links into the chat when I'm not when I turn it over to Carney, if anybody's interested. And then finally, like on a very real, but perhaps one step removed from what we're talking about with like personal injury, physical injury, harm would be like environmental damage that results from the practices that are like mining and other practices that are engaged in trying to obtain the resources, the rare or hard to extract resources from the earth to allow for computer systems and AI systems to function, or the energy needed to run the computers that allow for AI systems to function. So there's a huge sort of spectrum of potential harms, some of which are recognized in tort law and others which are not, or at least yet have not been recognized. Carney, if you want to add something to that.
You're muted, Connie.
That's an unintentional tort. So no, I think you gave all the major examples, so not much to add. I think that we'll probably go into this in a few seconds, how the existing legal frameworks fit to the different examples. In certain jurisdictions, certain legal frameworks only apply to physical damage, and in others, it's not the case. So I think we can go further on and see what the law has to say or will have to say about those types of damages.
No, exactly. That would be that was like my next question. Actually, following up on someone commented, like, "Oh, are we going to discuss negligence?" Yes, because that's a big point of difference between Canada and the U.S. We're gonna unpack this in a few seconds, but so we're sharing some resources also in the chat, and I forgot to mention something, and I'm usually very good at promoting other people, but not myself. So some of the points that we're going to discuss today are like in the book that we published last year with Teresa Scassa, and it did collections with some of the leading Canadian experts. And so Professor Thomason authored the book on torts. And the book will be available in open access at the end of the month. So I will share in a few seconds the link in the chat if you can join. And also Dr. Shagal Fefrakan published a well-cited paper, it was like 2 years ago, discussing tort liability for the thinking algorithms, discussing the spectrum of autonomy. I'm sure we're going to discuss this during our conversation. But yeah, so with this in mind, maybe Kristen, if you could explain to us like how Canadian law is considering those kind of harms, if at all. And I will start with you, Kristen, because we are in Canada. So for once, let's consider Canada first before the US.
Sure, yeah. And there are some really interesting contrasts between Canada and the US, which Carney and I have spoken about. So we'll sort of highlight that between our back and forth. But Canadian tort law is, very generally speaking, is sort of divided into three types of actions based on the level of wrongfulness that the defendant has engaged. So the defendant would be the person who the injured party is claiming has caused them their harm. And so that is intentional torts, negligence, and strict liability. So intentional torts require that somebody acted with intention. That those will be helpful in some ways in dealing with algorithmic harm, especially where there's no sort of commercial or contractual relationship between somebody who's been harmed in some way and the party or parties that they're saying have caused them that harm. This will be a narrow category of circumstances because that defendant or defendants have to have acted with intent. Like they have to have meant to harm the plaintiff or do the thing to the plaintiff that the plaintiff is alleging, which I think in many, many, many instances is not going to be the case with algorithmic harm. Often what we're going to see, I suspect, and based on what we've already seen in practice over the last handful of years and up to a decade, is where an algorithm is deployed and something unexpectedly or allegedly unexpectedly takes place because of a failure maybe to properly audit the algorithm or the data that's used to train the algorithm or the social context in which the algorithm is put out into the world. And so that category of wrongfulness would fall within negligence. So negligence is basically where a plaintiff is alleging because the defendant failed to take care, so to exercise care towards me, the plaintiff, I suffered a foreseeable harm. So they should have known that this could harm me and they should have taken better steps to mitigate that harm and to avoid it. The third category of tort actions, which I actually think could be very helpful in dealing with some circumstances of algorithmic harm, but in Canada is not going to potentially be very helpful, is strict liability. And strict liability is an area of tort where a plaintiff can bring a claim against a defendant where the defendant could be held responsible simply by virtue of having created this risk and put it out into the world. So they didn't have to act negligently. It's not that they failed to take reasonable care or be careful enough towards the plaintiff. And it's not that they ever intended the plaintiff to get harmed. It's just that the courts say that by virtue of creating a really significant risk, we're going to hold you responsible if someone should be harmed by that risk. And as we are made increasingly aware of the many ways in which algorithmic systems can cause, in some cases, pretty extreme and life-altering harm to people and to groups of people, in my eyes, strict liability becomes more and more relevant as an area that might be appropriate in certain contexts of deploying algorithms into society on the basis that the whole theory of why strict liability exists is you've created a really significant harm where we can imagine that people, would suffer if this harm materializes. And therefore, and especially if you're profiting off of the creation of that harm, therefore, we're going to say that you should be responsible in a way to ensure, although I know that's kind of a loaded word, but to ensure people if they should actually be harmed by this thing that should be pretty obvious. So in Canada right now, the courts have been very, very restrictive in where and when strict liability tort claims are going to exist. And product liability, which in the United States is handled often under strict liability, in Canada is treated under negligence. Oh my goodness, I've embedded that word in my brain. Under negligence. I do this to my students in class sometimes too. Sorry. So negligence has this higher threshold that the plaintiff has to make out, which can be good in some ways, but in certain circumstances, we might say is actually creating a huge barrier to plaintiffs actually getting compensation for their harms. So I think there are some really interesting ways in which the Canadian, and I'm talking specifically about sort of the Anglo-Canadian colonial tort law system, could have some conversations with the U.S. system and maybe draw some lessons learned between one another, and not exclusively those systems, but for the purposes of Carney and I having this conversation, I think that would be one relevant area to think about reform. Carney, I'll flip it over to you to talk about the US context, because I think that segues.
Sure, with pleasure. I really try to follow all the questions in the chat, but usually they say that women are good at multitasking and I'm horrible at it. So I'm still stuck at one of the very first questions that said, okay, but how can the law know how to regulate what's going to happen in the future? And it's a great question. I have a lot to say about it, but in our context, I will use that question to start with what the U.S. is currently doing with respect to AI-induced harms. It's not directly related to tort law, but rather on the complementary measures of trying to minimize risks, in advance, not after they happened. And there's this the bill they've been trying to pass for the last 3 years, but now it's been filed, the Algorithmic Accountability Act, which classifies different AI systems according to the risk they pose, and obliges companies to audit their systems and report different findings, in the hope that if this process is more transparent, then potential harms could be minimized in advance. So the focus of the U.S. currently is on that. And with respect to tort law, as Kristen said, I think the two governing frameworks would indeed be negligence and products liability. With respect to products liability, it's interesting because in the U.S., products liability, the way it's analyzed, it depends on two things. First of all, it depends on the state. Different states have different rules. When what makes it even more complicated is that there are three major types of defects of products. One is a defect of manufacturing. So if, for instance, it's a car, then the manufacturer of the car used flawed material or forgot to put one, I don't know, engine, for example, used a defective material of the engine. And usually it's true in most states, this is subject to strict liability. The third, and I'm jumping to the third on purpose, third defect is failure to warn. For example, if I manufacture children toys, it's okay. But if I don't say that if, I don't know, you shoot a toy gun too close to the eyes, it might be dangerous, then it could be a product defect because I needed to warn the consumers how to use or not use the toy. And the second, which is most relevant to algorithms, is a design defect. So in the physical world, to take a car, for example, and there's a famous case about it, if the designers of the car put the gas hole too close to the ignition system and every once in a while there was an explosion, this is a design defect. And it's most relevant to algorithms because algorithms too, it's not physical, but the systems could be designed in a safer way. Now, what's maybe complicated is that the different states analyze the design defect differently. Some states look at the consumer expectation test. Would the consumer have expected it to be more safe, or would it have expected it to be as safe as it was? And if it's different than what the consumer would have expected, then it's a defect. But now more states, with respect to the design defects, go to a more negligence similar direction, where they say you do a risk utility analysis, and if the designer of the system, the AI system, for example, could have undertaken safety measures that were not more expensive than the expected damage, then they should have done so. If they didn't do so, there is a defect. Now, it's still products liability, and certainly several states do impose strict liability on those defects. So different than the approach in Canada. But we need to know that in the U.S., it really depends on the state. So that is one major framework that would be used and is used currently. And another framework is negligence of the company in the way it chose to instruct the designers, et cetera, et cetera. But on that point, something interesting that happened in the U.S. in 2018, there was a lawsuit filed against General Motors because one of its autonomous vehicles hit a motorcyclist. And the lawsuit alleged all the claims we've discussed, that they say that the autonomous vehicle was a defective product and subject to product liability. They say that the company itself was negligent in many different ways about this system going on. It shouldn't have gone on the road to begin with, and when it did, there should have been more safety precautions. But another interesting element, which I'm sure we'll talk about it later, was that the plaintiff also alleged that the car itself, when it hit him, it was negligent because an autonomous vehicle, according to the plaintiff, it's no longer a product. It's not a toaster. It's not a coffee machine. It's something that does unpredictable things on its own, and it supposedly does so better than humans. So when it acted and swerved to the left and not to the right, it should have, it was not reasonable for the system to do so, and it was negligent. Now, what's unfortunate for our discussion is that this case was never really discussed. It was never decided by the court because they reached settlement way before. But that's an also direction to consider, which we could later maybe elaborate on.
Yeah, thank you, Ben. But that's that was one of the questions I wanted to ask you, Dan, and kind of following up also on the question from the chat that you flagged at the beginning, Connie. How can we regulate, those kind of system and those kind of harms that we don't not yet know? And also, I know that at the beginning in the chat there is some conversation about the closed captioning that at least on my hand is working, and I can see that it's working way better when Kristen is talking than when I'm talking or when Connie is talking. I didn't thought of this, but that's a harm to me. I feel like, yeah, thank you for reminding me that I have an accent, a French accent when I speak in English. And I'm sorry to Microsoft for not being able to fully understand me. But so, yeah, how do we, regulate this? How do we think about this? What is so different about AI systems when we're looking into this? What do we need to start to think about for tort reform? Because automation is not new. We had like automated product for like so many years and so many like cases. The same for torts, for contract. Like automation is not new, but it does kind of like and I love that word that you have in your paper, kind of like the thinking algorithms, and there is an autonomy maybe of the product of the system. How do we deal with this, and how is it like different from a tort perspective?
You're absolutely right, because I think a preliminary question we should ask ourselves is why all of a sudden everyone is, we're really glad that there are so many participants, but why are everyone all of a sudden interested in this topic? Because we've had automated systems before. And an example I like giving is that of an autonomous pilot, because, it's very important, an automated pilot, because the autopilot, if you think about it, it's pretty similar to an autonomous vehicle in the sense that a machine, a system, has to make its own decisions on how to steer a vehicle. And if it gets it wrong, there's a life and death consequences to it, just like an autonomous vehicle. But autopilots have been used for decades now, and there already were accidents related to autopilots, and no one said, we should come up with a new tort framework to apply to these types of new automated systems. What they did in the U.S., for example, is simply applied products liability as against the manufacturers of the autopilot, as well as negligence claims against the manufacturers, against the airline, sometimes against the pilots. So why not do the same? I did so someone asking about the driver, the human driver. Yeah, why not do the same? Apply products liability against the manufacturer of the autonomous vehicle. And maybe there's a liability of the human driver. What's so different? And the truth is, I think a lot is actually different when you think about it. And I can give a full lecture on that, so I'll just give a few points, but there are more. The main thing I think is that if you compare autopilot to autonomous vehicle, the decision making is very different, and the level of foreseeability of the manufacturer is very different. Why? Because if you design an autopilot, then you have a very limited number of threats you have to consider in advance. Maybe the engine will malfunction. Maybe in rare events, a bird will get stuck in the engine. But in general, unless aliens start falling from the sky, you know in advance the type of dangers you need to have the system be prepared for. And also, it's pretty rare that it happens. Usually, the system, you turn it on and nothing really happens. It doesn't have to make new decisions, and that's it. So the manufacturers, I'm not saying that it's completely safe. And I'm not saying that there are no surprises, but in general, it's known, everything is known in advance. But if you take an autonomous vehicle, and we're giving the example in the transportation sector because, it's very well developed there. We could have also found other comparisons in the medical field, for example. But if we take an autonomous vehicle, think about the decision-making process of the car that the manufacturer needs to think of in advance. First of all, it encounters new threats, not once in the blue sky where, birds get stuck in the engine, but every single second you have, both the frequency of their threats and the number of threats. Because every single second there are other drivers, and there are other autonomous vehicles, and there are other regular vehicles, and there's we're going towards a smart transportation system. So the lights and maybe the railroad system, they're all going to feed information into the autonomous vehicle saying, oh, the light is about to go red, so you need to slow down. And there could be also a cop on the road in an ambulance. And every split second, the car has to make decisions. Do I turn left? Do I turn right? Do I slow down? It's very different than an autopilot in the sense that when a manufacturer has to anticipate all the potential harms, there's no way they can do so. They could tinker with the systems and know later, like try to test certain scenarios and know what the car would do. But, very a fraction of the potential, scenarios out there. So this, in torts law, foreseeability is important. In negligence cases, you have to show that the damage was foreseeable, that the person that you now want to hold liable could have foreseen the damage. And this assumption is true for regular automated systems. It's not necessarily true for autonomous systems. And plus, another difference that an autopilot, it was a supporting system. The pilot is always there to override it if there's a sense of danger. But now, with autonomous vehicles, in certain countries, I'm currently in Florida, so for example, in Florida, it's allowed for these systems to go on the road without a driver at all. So not only is the system making many, many decisions all the time, with the unexpected circumstances, but it's no longer the person in charge. It's the system in charge, for good or worse, or worse. And often it is for the good, because these systems are getting better and better than humans. So we want them to make the decisions. But we have to understand that it's no longer merely a supportive system. And there are many other little differences between merely automated systems to autonomous systems. But maybe we should go back to that later, or I don't know, Kristen, if something you want to.
Yeah. Maybe, Kristen, if you something you want to add, and also because I know you have worked a lot on drone, but also on technology facilitated violence and abuses against women and other marginalized communities online. Maybe, I don't know, it could be interesting to see how it's changing with AI. I know maybe it's even more complex to design legal framework to support those victims.
Well, I think Carney has really, eloquently laid out some of the foreseeability issues, which will present a huge burden to plaintiffs in seeking compensation, especially in Canada, where we really are going to be looking to the negligence framework. Negligence is very driven by foreseeability, and so that is going to present a range of different challenges for plaintiffs to actually make out their case, even if if we're talking about, say, a vehicle collision, it might be also complicated when a person is driving the car and relying on some sort of auto, some of the sort of supportive systems that Carney mentioned. It just becomes even more complicated for plaintiffs to make their case when we're talking about fully automated systems. And so I think there's been a lot of really interesting work done about the black box problem, which is this idea that we can't actually necessarily understand exactly what went wrong, and that there are going to be these sort of foreseeability traps for designers, in the sense that they're not going to be able to predict, like Cardi said, every single possible instance or issue, and so can't necessarily prepare and give strict rules for each encounter that a car might face in terms of what that vehicle should do. I actually put into the chat a really great paper by Cynthia Koo on this foreseeability question in negligence, and she proposes some really interesting solutions to how to approach the foreseeability issue, in particular with respect to emergent discriminatory harm. But thinking about the negligence tort as being sort of the primary go-to for plaintiffs, I think I'll just layer into what Carney already wonderfully laid out some other considerations. Like the first consideration is that when we're talking about automating something, presumably in a lot of cases, if not maybe all cases, we're talking about automating it so that humans step back. Like we're delegating decisions to machines so that humans step back and don't do that decision making or don't engage that conduct. Like an automated vehicle is automated because then the person's not driving. Like otherwise, why are we automating vehicles? And that can create a challenge to plaintiffs in the sense of, with this sort of distance between the person and the process, we might have trouble figuring who the person is behind the process in some cases. That's not going to be the case everywhere, but in certain circumstances, it's going to be very difficult, if not impossible, for a plaintiff to identify their defendant, which is a huge barrier to accessing justice if you can't even name the person who you think is responsible. But that sort of like remoteness between the process and the person who might actually be responsible for introducing it into the world or designing it improperly or whatever the case might be, that sort of removal also comes into the negligence analysis. In Canada, and I believe in the United States too, negligence is driven by two concepts. Foreseeability is probably the most significant. Like, could you foresee this harm would occur and then you should have done something? But the other consideration is called proximity, which means the closeness between the parties. So you don't owe a duty to every single person in the public to make sure that you don't harm them in some way by virtue of your conduct. You owe a duty to specific people not to harm them. And that duty is based on foreseeability on the one hand, but it's also based on proximity. And you don't have to have like an intimate relationship or anything. The person can be a stranger, but there has to be some kind of connection between you and your plaintiff for you to be held responsible to take care towards them. The whole premise of automation is to create remoteness. And so we're actually undermining proximity by automating. And that's not to say that's not something that can be overcome on a case-by-case basis. But I think something to really think about is if we're going to be relying on negligence as sort of the primary action for dealing with algorithmic harm, we should maybe think about the fact that like automation actually is contrary to the very theory of negligence, which is that, there's a separation and a remoteness here between the parties. And so not only does that create sort of a practical challenge in terms of who's my defendant, but it can also create a legal challenge in the sense that the plaintiff has to show that we were close enough that the defendant should care about me and take care towards me. And that in some circumstances that might be lost or very difficult to prove.
That's
and then
really,
I think, oh, sorry, go ahead.
No, just really interesting because I think it might be different between Canada and the U.S. or Israel, where indeed they also, the element of the existence of a duty of care exists, but it's been interpreted very, very widely to include almost anything. So interesting that in Canada it's like a more real requirement.
Yeah, like especially in recognizing a duty of care, there would have to be like this proximity in terms of an expectation that I might harm. Like proximity and foreseeability are very tightly woven. So like an expectation that I might harm this person because of our proximity. So if I'm an automated vehicle manufacturer, I can imagine that there are going to be people who are going to be in my car, and I can imagine there are going to be people on the road who might encounter my car. And so I might have a sufficiently proximate relationship with those folks. But, if I'm the owner of a product that acts in some automated manner, I might not have this, and I sort of set it out into the world to act in that way. I might not have this sense that like, I should have anticipated that person could be harmed by my product. I might not have a sufficient proximity anymore to meet that, for that person who might be harmed, to meet that threshold or that barrier. Just to quickly note, I guess, a couple of other little observations that I think build on what Carney was already saying. Another consideration with automation is the perception of infallibility, which I don't think is necessarily new, but is certainly going to be a consideration when we're talking about algorithmic harm, which is the idea that different parties will engaged in the process of resolving a dispute related to algorithmic harm, will look to the algorithmic system and say, well, it should be better than a person. And so it's an improvement on human decision making, or it's an improvement on human conduct. And that can play into both the standard of care, which was already mentioned. Like, we would expect that you should be using, like, I expect, 10 years in the future, does the court now expect that everyone should be using some kind of automated vehicle because it's known to be safer than humans driving cars? And if that's the case, if somebody's driving their own car, have they now failed to meet the standard of care because they're insufficiently safe on the roads? But then also, even in litigating in court, the perception of infallibility, that like a mortgage system, a mortgage sort of software system, is going to make a better decision or a less biased decision than a human banker because they're not affected by human biases and human frailties, when really, if it's trained on historically biased data, it's actually replicating problematic decisions from the past and bringing them forward into the future. And so there's this consideration of the perception of infallibility that I think could play a practical role in litigation as well. And then the last thing that I would just mention is that in tort law, and like, I'll speak specifically to Canada, but tort is often also driven by policy considerations. There's policy embedded. There are pauses through the negligence test where courts are asked to think about the policy impact of what they're doing. And one way in which that's going to be relevant when we're thinking about tort litigation related to AI is the ways in which courts will view innovation as a policy, as a social good that may override other interests, including perhaps like plaintiffs seeking compensation. And I'm not saying that this is going to be every single judge is going to think that way, but there is actually a lot of precedent for changing the law to benefit innovation as seen as a positive policy goal, including within tort law, which is going to be very relevant here. And I can very much imagine will be in the arguments of defendants in a lot of cases that engage algorithmic harm. The aviation industry basically single-handedly changed a few tort doctrines because of the perceived social good of innovation in aviation. And I think we're at a similarly sort of, not to use an overused term, but like a similarly disruptive moment where we might imagine that courts are going to shift doctrine to accommodate policy. And I guess what I would say about that is just that there needs to be a lot of caution around sort of a blanket approach to viewing, increasing automation or delegation of decision-making to machines as like, a blanket positive for all of society, because we already have so much evidence of the potential for harm, and in particular, the potential for inequitable distribution of that harm that, I think that really needs to be pushed back on if we start to see that in court decisions.
That's actually a nice segue to my next question to discuss, what kind of reform, like clarity we would need from court, from legislators to address some of the new challenges raised by AI-based system and project. And I think, Kristen, you put your finger on one. Also, the issue with the legislator, maybe even more than the courts, is like God innovation. Every time that it's like, oh, we need to protect privacy. Oh, but you're gonna block innovation. We need to protect consumers. Oh, you're gonna block innovation, as if every kind of innovation was good. What kind of reform we may need, if any, or like, is the current legal framework okay to deal with what might come? I don't know who wants to take it first. Maybe Connie, as I think Kristen, you already started to reply a bit to this question. So Connie?
Sure, with pleasure. So there's one direction that I think Kristen also is in favor of stricter liability. And it's also the direction that we're talking about Canada and the U.S., but this is also the direction that the EU is going towards. And the EU, for example, says they will, again, classify AI systems according to their potential risks. And the higher risk system will be subject to a strict liability regime. And of course, it has its benefits because it gives an easier redress for the injured to get compensation, and it provides certainty. Because if something happened, then you don't have to start going for who's to blame, and how are the many different tortfeasors related, who contributed what. I mean, it has more certainty, and it's in that sense clearer. It's not a direction I support because of what Christine elaborated on, and this is the fear of a chilling effect. These AI systems, on the one hand, they pose like new threats of great magnitude. The different harms they can cause, the fact that no one can really know why they decided as they did, and maybe in 20 years we'll find out that, okay, it was better than humans, it was 90%, whereas the human was 80%, but in those 10% where it was wrong, there was a systematical error that really affected a certain type of the population, or I don't know, had like devastating consequences, and we will not know. So the risks are known, and some are really unprecedented. But on the other hand, the benefits and the opportunities are also unprecedented. So I think that the balance between the two, or the right policy to try to safeguard against risk, but also promote innovation, it's very challenging. And I lean towards a more negligence based approach. What I've written on, and it was very controversial when I started, but ever since that lawsuit I mentioned, as someone asked, it was Nielsen versus General Motors filed in California in 2018. Since it was filed, I think it's a new direction that could be gaining traction, is especially in those cases and in those jurisdictions where a human tortfeasor is subject to negligence, which means that if the person was reasonable, then they will not be liable. And if the person was not reasonable, then they will be liable. I think of a reform where an AI system that caused damage, an autonomous car who hit someone, or a medical application who misdiagnosed the patient, you would also look at the reasonableness, not of how the system was designed, but of the specific action or inaction of the system, and determine if it was reasonable or not. Now, if it was reasonable, then there's no liability, exactly as if it were a person. And if it wasn't reasonable, then we of course we will not demand the AI system itself, like the robot, to pay damages itself. But we will find a deep pocket. It generally could be either the manufacturer, or in the EU, for example, they're going towards the direction of the operators of the system. And to my opinion, it depends who has more control over the system. In certain cases, it could be the manufacturer. The manufacturers of autonomous vehicles, they have the information on how it's manufactured, what risks they foresee, how they can minimize them. But in some cases, it could be the operators. If you're the owner of a huge autonomous vehicle fleet, and you buy vehicles from various companies, and then it's something I haven't mentioned, but you can also add on many other AI systems, like as patches. So there's dynamity. I don't know if there's a word like that in English, but dynamic nature of these systems. You can add more and more systems that will communicate to each other. So in certain circumstances, it's the operators of the system who will be best positioned to minimize risk and have most control over these systems. So to go back to my proposal, what I think makes sense is to look at the reasonableness of the system itself with respect to the specific damageful action, and if it was not liable, then hold either the manufacturer or the operator liable for its actions. Of course, there are practical questions of how to do that. How do you know if an autonomous car was reasonable or not? I can go into that if you would like. I don't know, Florian, if we have time or not.
You can unpack a bit, or I'm sure we can come back to this later. There's so many questions that I think linked to this. So up to you, what you prefer.
Okay, so I will just say, I'll try to do it quickly. Reasonableness, how do you know if tortfeasor was reasonable or not? We either compare it to others. In medicine, that used to be the main test. If other physicians would have done the same, then the physician was reasonable. But the problem is we don't really have many other autonomous systems to compare to, because it's a novel technology and there are not many companies doing the same thing in the market, and there's not enough experience. So that's one thing. The other analysis is the normative analysis related to the policy consideration that Kristen spoke about. What the court wants the public or the systems or the potential tortfeasor to do. They want us to aspire to better standards of behavior. So they usually do an economic analysis, and if there are cost-effective precautions to take and they were not taking, then it's not reasonable. But here again, when you have algorithms, it's a little bit problematic, because when we try to be normative, the court is normative, they're trying to set or direct the behaviors of people to do the cost-effective thing or the moral thing, then people can interpret what it means. But algorithms, you tell me you need to be reasonable, you need to be more efficient. It's a more vague term. So a tort law, you're trying to deter potential tortfeasor from causing tort. And here you have algorithms who are not deterred and do not understand vague concepts. So I acknowledge that trying to understand or to analyze what's a reasonable algorithm is like there are many obstacles to it, but I think they could be overcome by having like a joint test of comparing it both to the reasonable person and the reasonable manufacturer together. I mean, it's something I elaborated on in a paper. It's technical, but what I think the good thing about it is that you hold the algorithms to a threshold of humans, but still it's not sufficient, because the whole point is that algorithms could do better than humans. We want to hold them to higher standards, and with a joint test like that, we can do so. And I think it has various advantages. One of them is that for the analysis of reasonableness, you do not need to know why the tortfeasor acted as it did. So many people say that AI systems are black boxes, they're not transparent, they're not explainable, we don't know why they acted as they did, which is true. But also, if you have a driver who hit someone else and then said, oh, I got banged in the head, I don't remember why I did so, the court can still determine if they were reasonable or not. So they could do the same for AI systems, even if they do not understand why they acted as they did. And a last advantage I would mention, that I think it has to do with some of the questions, is that it's neutral. Because even if the technology changes and who knows what's going to happen in 2 years, the technology will be much better. Okay, but we can still apply the reasonable standard analysis on that.
I have so many questions, but first I will give the opportunity maybe to Kristen to give a take on like what is maybe needed.
Yeah, and I'll be brief because I can see there's also tons of questions in the chat, so it'd be really good to open it up. I haven't been able to follow them all. Sorry, I'm like Cardi.
I'm trying to
hone in on one or two things at a time. So I mean, I find Carney's proposal incredibly interesting, and I'm thinking through lots to do with it, and I think it's quite helpful to be thinking about like, how do we approach this? I think a couple of things that jump out to me when I think about like tort litigation for algorithmic harm. I mean, one is just like the sheer complexity of that kind of tort litigation, or like what could become quite a complex litigation, like so many different actors, individuals, programmers, designers can be involved in the creation of a system, that it can be quite conceptually challenging to imagine, like, how are we going to identify causation, like who caused this problem, or how are we going to sort of pinpoint responsibility? And we haven't even gotten into the complexity that's added when we add contract law into this. So if we're talking about an AI system that's been deployed in a commercial relationship, you're going to invariably have some contracts, you know, between the purchaser and the seller, and then possibly between like all of the different parties involved in the creation of the algorithmic system itself, which will contain a variety of different relevant provisions that might distribute liability and responsibility between parties as well. So we haven't even broached that topic yet. So all of this is to say, like, it can become quite complex. And so that's something that I find so interesting about Carney's proposal, is it's aiming to sort of simplify some of that complexity. When I think about that kind of complexity and like how could, legislatures or courts maybe think about streamlining some of the challenges that are going to arise in litigation over algorithmic harm. It's always helpful for me or interesting for me to think back to like, what is the actual goal of tort law? And, in Canada, one of the driving goals is this concept of corrective justice, where we're sort of focused on restoring the plaintiff back to where they were before they were injured. And the defendant does that through compensating the plaintiff. Something that hasn't been as significant of a focus in the Canadian tort law system, but has been, my understanding is, much more of a focus in the U.S. system, is the goal of accident deterrence. So really trying to deter, especially large companies that produce a lot of goods that go out into the market, deter them through sort of economic disincentive from creating products that can harm people. There are weaknesses to this, like that we start measuring, what we should or should not do based on how much it's going to cost. And then we can compare that to how much profit we're going to make and maybe accept certain liability because we'll make more profit than we'll pay out in damages. But the general notion of accident deterrence, I think, could potentially motivate some rethinking in the Canadian system in terms of how it approaches dealing with some of these challenges. And I can elaborate on that more as well, maybe in the Q&A. I don't want to take up too much time about that. But really, my main point here is just like, I think, if we are thinking about like a shift in some of the dynamics for compensating harm, arising from potentially increasing instances of algorithmic use of algorithms, we might start thinking about even just like at the theoretical level, like what role is tort law even playing here? And tort law is not like some progressive bastion of, fixing social ills necessarily. That might be controversial to say, but, I'm happy to debate about it. But like, for one, tort law measures your harm, your human dignity harm or your physical harm or your psychological harm in dollar values. Like it's driven by economic and commercial ideas. And so it's also really important to recognize just the limits of tort law itself in giving us sort of an outcome or a resolution that we feel happy and comfortable with. So stepping back from all of that, I do think that there can be a really important role for the legislature potentially in clarifying how courts deal with some of these challenges, like the foreseeability and proximity challenges that we talked about, like the complexity of identifying defendants. And, it's not unheard of. Actually, it's not uncharacteristic for legislatures to step in when new technologies create a change to social dynamics that we don't want to wait for courts to be responsive to. Like courts can only respond after the harm has occurred, but where we need some kind of clarity up front because we've identified some issues, including the inequity or access to justice issues of plaintiffs even being able to make their claims and push forward for new tort, new recognition of harms or new processes for considering evidence, that sort of thing. So I do think that this is an area, I'm increasingly inclined to think that this is an area where there could be some really good work for legislatures to do in clarifying at least some of the most complex components. But always going back to like, what is it that we're actually trying to achieve by using tort law to deal with this, as opposed to another area of law or even some other form of thinking about these relationships.
Yeah, and as you said, and we will come back to that point because, as you know, I have so many ideas and opinions about AI and contract law and like the relationship with torts. That was kind of my final question for today, so we'll come back to this. But I will. There's been like a lot of question and conversation in the chat, especially around the question of litigating AI. And Kristen, you just touched upon this, and also Connie a bit before. And maybe I would like to come back to this. And I have a bit like your thought on this. I know, Kristen, like I think in all your comments you discussed some of the calls, for like rights to audit systems, like the call for transparency, and some people are also mentioning this in the conversation. There's like that whole conversation around maybe a right to an explanation and what exactly it contains. It's subject to too much debate in the EU. There's been proposal in Canada. How do we litigate AI? Like someone in the chat was like, how do we cross-examine, an algorithm in court? So if you have like a tort that might like fit the bill for you as a victim, like how can you prove this? That actually there was like a negligence or 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 can you like call upon which defendants, etc. And that would be like my own kind of twist too. Is like transparency the perfect answer? Because like one of my concerns, what we see in the privacy area, is that with the so-called transparency, we end up with like tons of papers that most people don't read, don't understand, and then corporations be like, oh, but we told you about this. That's all fine. No, like, do you need to be an AI engineer to be able to understand this kind of documents? That's kind of, I think, some of the challenge. So you touch upon a bit on this now earlier, and because there's been so much question in the chat, maybe it would be nice if you could like discuss this a bit more.
I'll start. So it's true. I mean, the process is expensive, is slow. It is for products liability in general, or for systems that cause damage. You don't even have to be AI systems for the process to be long and slow. And one of the criticism in the U.S. is that such cases are not taken by lawyers. I mean, they need the prospects of winning need to be very, very significant for a lawyer to undertake such a case, because it's long and it takes time, and there's nothing guaranteed. So there are many injureds who do not have access to the legal system because of it, and this is regardless of AI. So when you add AI, it only gets worse, because you no longer need one maybe type of experts. You need a few. For example, if it's a medical application that goes wrong, then all of a sudden you need a medical expert to explain what the medical application should have done, but you also need a technological expert to say how it could have been designed otherwise. So I completely agree. I think that if you go back to this proposal to look into the reasonableness of the specific action, and again, it depends exactly how you do it, but it could be a little bit more easy than trying to see how the system was designed to begin with. But try to focus on a specific action and see if it was reasonable or not. But it's definitely a challenge. And someone asked us about a completely different alternative of insurance. How could this play a part? So another direction that certain jurisdictions are considering are no-fault insurance schemes. Countries are saying, okay, we understand that to figure out which party was liable, or which tortfeasor contributed to the damage. For example, in the cases of autonomous vehicle, where they could be the driver and the manufacturer of the car and the AI system of a different manufacturer that the owner put in the car. So instead of trying to figure out how they all contribute to the damage, saying, okay, just leave it to the no-fault insurance scheme. Every injured of an autonomous vehicle accident will get money out of a pool that could be collected from the car manufacturers, from the purchasers, and I think it's a good solution. It's a good solution, especially in those jurisdictions where it already exists. For example, originally from Israel, where we have no-fault insurance scheme with car accidents. So everyone involved in the car accidents gets paid from the insurance of the driver of the car, regardless of fault. And there are very, very few exceptions. And now the Israeli Minister of Justice are considering applying similar rules of no-fault insurance on autonomous vehicles as well. And I think it's a great solution, but the limitations of it, at least from the Israeli experience with respect to regular car accidents, is that the cap is very, very low. People do get compensated, but with low fees, and then they cannot go back and try to retrieve, the additional amounts of damage from the relevant parties. So like there's goods and bads to it. Some say that with respect to AI systems, this problem will not be as significant because the companies involved, at least in the autonomous vehicle industry, are very rich. They're deep pockets. Plus, the number of accidents are supposed to drop dramatically. This is the whole point of autonomous vehicles. And if that's true, then even if the insurance of these cars will mean that the cars become more expensive to buy, because the manufacturers will only try to collect the additional amount from the buyers. It's okay. It doesn't matter. It won't be significant. If it's true, it's great. We have to remember that not all industries are like that. Like, the transportation sector. In other industries where AI is developed, sometimes in the medical context where it's could save life, the companies developing it are at least at the beginning do not have many funds, cannot charge very high insurance premiums from the potential buyers. So I guess it's sector specific and country specific.
Kristen, do you want to get anything?
Yeah, sure. I would just, I guess one of the challenges here is we're talking about such a huge range of different potential harms. And so trying to think about like what's a common theme, because obviously I think like depending on the circumstances, you're going to have different considerations for how is this actually going to be litigated, that might range from, the actual costs to the plaintiff on the one hand to like the actual application of tort doctrine on the other hand, right? Or maybe those are on the same hand. Anyways, we're talking about a huge range of different issues, but what are some of the common themes that thread through these issues? I think, the idea of locating responsibility is one big theme in terms of identifying who ought to be responsible. And in thinking through litigation, that's where things like creative arguments, like that courts, this isn't totally creative out of nowhere. This is drawn from case law and things, but thinking creatively about how to persuade courts, that who is the entity that's ultimately profiting off of this, right? Like, do we have to get down into the weeds and think about every single party that maybe contributed a dimension to the creation of a product? But instead, let's think about like who's making the ultimate profit off of it, and should they absorb the costs associated with harm that might come from the risk that's been put out into the world? That's not an unheard of argument, but it may actually be one that requires some strategic thinking and some policy convincing in talking to courts, in talking to judges in relation to a specific encounter. So on the one hand, this idea of like locating responsibility and how can we make that more straightforward for plaintiffs. And then that's also beneficial for defendants to have a good understanding of like, where does my responsibility and liability lie? Could be one dimension of thinking through some of this litigation. And then on the other hand, we're thinking about situations where we might need courts or legislatures potentially to recognize new harms. Like I've just sort of skimmed through the chat and I've seen many references and a lot of concern, it would strike me, to the potential issues of discriminatory algorithms, which I think is an absolutely huge area of concern and consideration. But in some ways, the courts have limited the application of tort law here, at least in the intentional sphere. There's some really, really great scholarship out there about opening up negligence law to considering discrimination claims that I think would be really relevant here. But you have to, as a plaintiff, identify a kind of harm that the courts have decided is compensable to actually have any success in tort law. Like you can't just sue in negligence if you don't suffer damage, and there's case law that defines what damage is. And oftentimes we're really coming back to like personal injury, psychological injury, or some kind of financial loss. And it can be very difficult to square harms that intuitively feel like they should be litigable, that we should be able to litigate through tort law, into that somewhat narrow conceptualization of what counts as harm. And so I think that the concerns that are coming up in the chat and that have been raised by a number of authors, deserve a lot of attention from courts. And this is where, sort of going back to my earlier comment, but this is where legislation could actually be really helpful in just sort of streamlining some of this so that it doesn't involve or entail a number of different huge court actions that cost a lot of money and that are really only available to some people to bring forward, and would make things more straightforward for all parties involved in the litigation. Few other comments that could come up, but I guess the very, very last thing I would say is tort isn't unfamiliar with dealing with complexity. Like think about medical malpractice. That's a huge area of tort litigation. And like medical practice can be incredibly complex. And like there are cases where judges will straight up admit, like, I don't have any idea how this surgery works, but I'm relying on expert evidence. I'm looking to doctors to explain to me how these complex processes work. And I, as a judge, can bring my legal knowledge and expertise to bear on assessing how this should be addressed through the doctrine. So it's not that we're talking about like complexity makes this impossible to litigate. It's that we're talking about the kind of complexity creates practical barriers to plaintiffs on the one hand, and also presents us with new kinds of harm that might not be as easily recognized in tort law, but maybe that we as a society want to see recognized in tort law. And that's going to require a shift either by courts or by legislatures. I would just leave it there.
Exactly. No, but thank you so much. And Kristen, when I muted myself, I was about to make the point that you just made, following some comments. We had a very lively conversation, and some comments where I feel like with misrepresenting or misunderstanding the points that the three of us have been making. We're not saying that, and even like in the irony of the title, it's yeah, there is a play on words, but it's not that we don't want people to be liable. I think like the three of us, I've been working very hard for the exact opposite. And that's one point, and Connie knows this because we had a conversation earlier about this, and same with Kristen, like, is the fact that the AI itself is not the person that we want to sue, because from a social justice perspective, this is not what we want, because we need for the victims to be protected, to receive damages, which an AI can. So we need to be able to unveil the AI veil to go seek damages and sanctions against developers or like people operating those systems. This is like the whole goal of Connie's research, of Kristen's research, and of my research. So if you had misunderstood us, I just wanted to clarify this point. The three of us are very much looking to build framework to make sure that those people could be held liable and that consumers and citizens could be protected. And there was like some question in the chat also that maybe we could discuss, but I would like to come back one of the comments that you made, Connie, and also some people discuss trade secrets and this kind of, but so what, why developing all those systems? Because as you mentioned, Kristen, we sign contract for pretty much everything. And often like we sign without even knowing it. Then there is that a whole conversation to have about this, like liability waivers for those systems. Do you have like thoughts on, well, I also have some, but like how we can deal with this? Same with trade secrets. That might be also an issue with, showcasing the arms of some of systems. And we've seen this recently around the world with like whistleblowers or security researchers wanting to come forward, but then like sued in criminal courts in Canada or the U.S. Under those kind of frameworks. So yeah, how can we make sure that there is no like, even though if we develop a more like progressive and protective, tort framework, there is not like other pieces of Canadian law, U.S. law that can come and block those progress. Hello, Connie, if you have some thoughts, or Kristen.
You mean in terms of globalization?
No, like, so Kristen mentioned earlier, like the issue of having the terms and conditions of systems, with the liability waivers for the users, of the operators, and like the complexity of all the actors in presence.
The thing with the contracts law, I think it might not be sufficient because not all the players are known in advance. I mean, yes, maybe the manufacturer of a car could have a contract with its buyers saying that, I don't know, if the car hits, if you are hurt in an accident, then we are not liable. You chose to buy this car. It's there's a doctrine called you put yourself in the dangerous situation. But it would not apply, to pedestrians in the street. It would also not apply when the damage is is not caused by the car itself, but by the additional AI systems that the driver chose to install in its car. By the way, there's an interesting paper called Open Cars explaining this problem of, the unlike other products who leave the manufacturer, the plant, and stay as they were, AI systems are very dynamic in the sense that the owners themselves can add more and more and more systems that will communicate with each other, and one can feed misinformation to others, and then who knows why the damage occurred. So I'm not sure that the solution of contract I think it's very narrow. It's when we know who caused the damage and they have a contract with the injured. But I think it does not cover many of the cases.
Kristen?
Well,
yeah.
So I understood your question is sort of getting at, like, it's one thing to kind of streamline or imagine how tort law might deal with this, but we're going to have all of these other intersecting areas of law, and how do we ensure, or what worries do we have about that, making it more complicated again? So, like, no matter how streamlined we might get tort law, we're then also going to have to deal with contract law and intellectual property law and all of these other areas of law. And I mean, I guess like, my initial response to that is some of the challenge or complexity of dealing with this through private law, is that when you're talking about litigating in private law, this kind of comes full circle to, like, the very introduction of the talk. Like, you are talking about courts trying to reason through, like, what is your individual right? What is your individual harm that you've experienced? Like, there are limits to private law in terms of what it does and what it's meant to do. And I think, if we recognize that and start to maybe question, if this isn't going to be successful in giving us what we need, are we going to need public policy responses instead, right? Like, I don't really have an answer to how we deal with the complexity of the intersecting areas of law, because, first of all, I'm not an expert in all those other areas of law, but also, like, that just kind of is the system that we're talking about. And by no means is it the only system or the only solution, or should we pretend that that's the case? So I think this maybe takes us back a step, in our focus, in our lens, to say, as a public, as a collective, as a society, like, what are we concerned about? What do we want for each other? What kind of protections do we want to ensure we all have? What kind of base support do we want to ensure we all have, so that we can manage our lives through some of the challenges that might arise because of different, things being introduced into society. One of those many things being algorithmic decision making. Yeah, so it's maybe not the most satisfying answer to your question, because it's not a specific answer. It's actually a much more complicated premise to base our solutions on.
No, exactly, and I think it's actually like the kind of correct, sadly, the correct answer, and also like a nice way to, like, basically wrap up our conversation around this and highlight that it's not just that the question of what is AI harm, what are, like, those algorithms, what are they doing, is then, like, even the way our legal framework are built are, like, so complex in any countries, but especially in Canada, because not even, like, tort law and contract law, there is, like, the provincial system with, like, each provinces and territories having their own system, the common law with the civil law and then the federal level. And someone mentioned, like, maybe one day we're gonna have a new C11, we know have a new C11, but it's not the privacy reform. But yeah, that's been called for, like, maybe some federal statute that would help for this. But I think we also might need more, like, protection in the Competition Act that is here that has some provision to protect consumers. And we saw that the Competition Bureau used it against Facebook to protect. We can discuss a long time around that decision, but it kind of offered for the first time an actual protection for Canadians and the privacy of Canadians, but there is more to be done. So yeah, as it was mentioned in the comment, for sure, there is a lot of advocacy to be done to make sure that it's a very complex issue that requires to update so many pieces of legislation, but some of the issue you just pinpoint, Kristen, of like contract and other part of Canadian law, this is not an issue that's proper to AI. This is what we have for consumer protection, and that the Supreme Court of Canada mentioned in so many decisions recently how we need to rethink contract law as a shift of paradigm. In Canada, we need the same for torts. So yeah. On those words are like, there is no answers, but like we are working very hard to find something, to maybe have some solution to propose to policymakers. I would like to thank you both for being with us today, for sharing your expertise and your thoughts and your proposal. And thank you also to all our attendees and the great conversation. There's been a very lively conversation in the chat. I hope we have been able to answer most of the question. I know that some links have been shared. Maybe after the event, we will like send an email to everybody again with links to Professor Thomason and Dr. Shagal Pfefferkhan previous scholarship if you want to learn a bit more about what they proposed lately and other documents that were shared in the conversation. So thank you everybody again for joining us. Thank you so much, Kristen and Connie. We had to postpone this event, but I'm so glad that we finally were able to have it. And and I will invite all of you to join us at the end of the month. We're gonna have a new event where we release a new movie that was funded by the Scotiabank Fund at the End Society Initiative about AI and surveillance in education technologies. So a short movie followed by a conversation with the team behind that film. And yeah, on this note, I will wish everybody a lovely rest of the day. Wherever you are in the world, we have like many times so it's represented today. Thank you, everybody. Bye-bye.
Thank you.
Thank you. Bye-bye.